This suit was commenced via the general form of complaint dated on 5 February 2019. It is the case of the claimant that he was an employee of the defendant by virtue of an employment contract dated 1st June 2017, which prescribes a probationary period of 6 months, and where performance is satisfactory, the employee shall be engaged and his contract renewed on a yearly basis. Claimant was posted to Haastrup PLC in Kebbi State, served his probationary period of 6 months. Thus, by 1st January 2018, he commenced his first contract of 1 year. Claimant's monthly salary was 300,625 naira, and defendant required by law to remit 18% of his monthly salary as his pension contribution. However, defendant remitted 11,900 naira instead of 54,112 naira 50 kobo monthly from 1st June 2017. 54,112 naira 50 kobo, thereby shortchanging him of the sum of 48,100 naira monthly from 1st June 2017 to August 2018, amounting to 589,400 naira. Claimant alleged that he performed his duties diligently, but was issued a termination of employment letter on 3rd day of August 2018 with immediate effect, without reason nor payment of his entitlements. This has hindered the claimant from sustaining another employment, as the termination by the defendant without reason deters potential from employing him. His case is that he did not complete the 1 year period for which the employment contract prefers. Thus, he is entitled to monthly emolument for the remaining 5 months, which according to claimant sums up to 1,503,125 naira, and end of year bonus payment of 36,933 naira, being part of the 60,000 annual bonus package. It is against this backdrop that the claimant initiated the action against defendant, seeking the following reliefs: an order of court declaring termination of the employment of claimant as wrongful and a breach of the contract of employment. B, order of court commanding the defendant to pay the sum of 1,503,000, being the amount of money the claimant would have earned if the defendant had allowed the claimant to work to the end of December 2018. C, order of court commanding the defendant to pay to the claimant the sum of 589,400, being the total shortfall in the payment of claimant's pension contribution for 14 months. D, order of court commanding defendant to pay to the claimant sum of 36,993, being bonuses due to the claimant for services rendered to the defendant from January 2018 to August 2018. E, order of court commanding defendant to pay 1 million general damages to the claimant for wrongful termination of his contract of employment without reason. F, order of court commanding defendant to pay the cost of action. And G, and for such other orders or further orders court may deem fit to make in circumstances. Defendant statement upon receipt of claimant's originating process. Defendant filed the statement of defense with counterclaim on 25th April 2019. A summary of the defendant's case is that the claimant was a contract staff, was never confirmed by defendant. Accordingly, claimant's employment could be terminated at any time in accordance with the terms of his employment. Hence, upon termination, claimant was entitled to 1 month's salary in lieu of notice and 2 days work pay, which amounts to 327,145 naira 21 kobo. However, in May 2018, defendant sent to the claimant the sum of 540,000 for the purpose of power, lighting, security, etc. And the claimant diverted the sum of 520,000 naira and has failed to refund same, despite a letter of demand by defendant on 24th September 2018, that when the sum of 327,145 naira 145 naira 21 kobo is subtracted from 520,000 naira, a balance of 192,854.79 will be outstanding. Defendant also averred that it has remitted all that is due to the claimant to his retirement savings account maintained with Stanbic IBTC pension, and pointed out that claimant's annual emolument was 3,850,000 naira, with end of year bonus of 60,000 naira payable only once a year. Also, that term of engagement expressly stated that claimant's annual pension contribution is 80,000 naira, with the defendant contributing 6,066.66 monthly as 10% of plaintiff's basic salary, while claimant contributed 5,333.33 monthly, which represents 8% of his basic salary. Thus, the total pension contribution of claimant on a monthly basis was 11,900. It was reiterated that the pension contribution of claimants is 18% of salary, which was computed as basic, housing, etc. Claimant being a contract staff of defendant is not entitled to housing and transport allowance. Rather, it was provided with reimbursable transport allowance to take care of his transport to field work. Overall, the defendant urged court to dismiss the suit with cause. There is a concomitant with the statement of defense, a counterclaim, and the reliefs in the counterclaim as follows. Order directing plaintiff, now defendant, to pay to defendant the sum of 192,854.79, being balance of 520,000 diverted by him without authority after deducting his terminal benefit of 327,145.21. B, cost of defending or prosecuting suit. Finally, a reply in response to defendant's statement of defense and counterclaim. The claimant filed a reply, that's on 29th May 2019. And the commencement date of hearing, actually this suit was initially before my learned brother, Honorable Justice Damlak, who was then the presiding judge in Sokoto Division. And this court resumed sitting over the matter on 1st November 2019, while the trial commenced on 19th March 2020. When claimant opened and closed his case, with claimant testifying as CW1, he adopted his witness statements on note filed 12th February 2019 and 28th May 2019. 5 documents were tendered and admitted in evidence marked as exhibits JNK 1, JNK 1A and B, JNK 2, 3, 4, and 5. The court had due to the lockdown in 2021, coupled with the JUSUN strike, this matter suffered unavoidable delay. And hence, to mitigate the delay suffered by parties, on 30th November 2021, the court had urged the parties to embrace the trial on record procedure as provided in Order 30, Rule 33 of the rules of this court. However, parties were not inclined to, and thus further delay in determination of the suit. After several adjournments, mostly on part of defendant opened and closed case on 26 February 2024. It called one Justin Ugochukwu Amuize, who testified as DW1. The witness statement on oath was adopted, which was filed 18 November 2022. And the documents tendered were admitted in evidence as exhibits D1 to 3. Afterwards, DW1 was cross-examined, re-examined, and defendant thereafter closed its case, while matter adjourned for adoption of final addresses. The final written addresses were adopted before the courts on 21st day of, I think that should be 15th, it should be July, let's confirm that. That's November. Can you please check this date for me? I think it should be 4th November. Yes, 4th November. The final written address was adopted on the 4th day of November 2024. And the defendant adopted the address dated and filed 21st March 2024, while claimant's final written address filed 15 July 2024 was adopted same date. Defendant also opted to reply on points of law orally to the claimant's final address. In the defendant's address, 2 issues were raised for determination. I'll read out only the issues. 1, whether determination of appointment of the claimant in a letter dated the 3rd day of August 2019 was wrongful and breach of contract of employment. If the claimant is entitled to the sum of 1,509,000 being the amount the claimant would have earned if the defendant had allowed the claimant to work to the end of December 2018. Issue 2, whether the claimant is entitled to the sum of 589,400 being the total shortfall in the payment of the claimant's pension contributed for 14 months, and the sum of 36,933 being bonuses due to the claimant for services rendered to the defendant from January 2019 to August 2018. Counsel has argued the issues with authorities to support. And in some counsel, that defendant counsel is urging court to dismiss the claimant's suit. Now to the claimant's final address, 3 issues have been formulated. The first issue is whether the claimant has adduced credible, cogent, and sufficient evidence at the trial to entitle him to the relief sought. 2, whether the deposition and testimony of the defendant counterclaimant's sole witness hearing is admissible in evidence before the court in this proceeding. 3, whether the counterclaimant has proved its claims before the court to entitle it to the relief sought. The issues have equally been argued. On the whole, the claimant's counsel is urging court to grant reliefs and dismiss those of the defendant. Now the decision of the court. Omara, are you still online?
Yes, my lord, I am.
How about Aminu Saidu?
Yes, my lord.
All right, thank you. So now the decision of the court.
As the court pleases.
Before delving into the substantive matter, I find it necessary to address the objection of the claimant's counsel challenging the witness statement on oath deposed to by defendant's sole witness DW1. Claimant's counsel relied on the cases of Aliu versus Bulaki, among others, and submitted that DW1's witness statement on oath is incompetent as it was signed in his office and not before the commissioner for oath. There is no doubt to this assertion, as DW1 under cross-examination admitted to have signed his witness statement on oath in his office. However, I must say that the appropriate time to raise objection to a witness statement on oath is at the stage of adoption. Once a witness statement on oath is adopted without objection, the witness statement on oath translates to evidence in chief, and it is no longer open to a party to challenge the competence of such witness statement on oath. See Obanigba versus Abibu, 2021, 3 Nigerian Weekly Law Reports, part 1762 at 84. Furthermore, in the case of Adejugbe and Aduloju, 2022, 3 Nigerian Weekly Law Reports, part 1816, 131 at 156 to 158, the Supreme Court held that by reason of the combined provisions of Section 4, Sub 2 and 3 of the Oaths Act, that the failure to take an oath or make an affirmation and any irregularity as to form of an oath or affirmation shall in no case be construed to affect the liability of a witness to state the truth. In this case, even if the first respondent's written statement was not made under oath or sworn at all, it will still be valid as the witness written statement intended to be given or given as evidence on oath in the proceedings, and nothing precludes the witness from adopting it as his testimony when testifying on oath in examination in chief in open, unquote. Flowing from above, it is my finding that even though the witness statement on oath was signed in DW1's office, the fact that it was later countersigned by the Commissioner for Oaths of this court in person of G. Bello Mohammed, the witness statement on oath is not fundamentally defective or without legal value to render it incompetent. In other words, the irregularity occasioned by signing the witness statement in DW1's office is not sufficient to render his witness statement on oath incompetent. Thus, this objection is discountenanced, and I so hold. I have carefully considered the case of the claimant, defense thereto, totality of evidence adduced in support thereof, and final written addresses of the parties hearing, and distilled 2 issues for determination, to wit, whether the claimant has proved this case to be entitled to the relief sought. 2, whether defendant counterclaimant has proved this counterclaim to be entitled to relief sought. The kernel of the claimant's case is that his employment was terminated by defendant without due recourse and compliance with the employment contract, and also that the defendant failed to remit the statutorily approved sum as his pension contribution and failed to pay his other entitled emoluments. It is the law that the burden of proof of a case resides on the claimant. This is an inflexible rule requiring that a claimant who is asserting must establish his case by adducing sufficient, credible, and cogent evidence. Otherwise, he loses his claim. See sections 135, 137 Evidence Act and the case of Olaniyan and Oyewole, citation provided. A claimant who complains that his employment was wrongfully terminated has the onus to furnish the court with the terms of employment and to prove in what manner the said terms were breached by the employer. See Okumu Oil Palm Company Limited and Iserehem. Thus, the claimant has by Exhibit JNK 1A, which is the employment letter, proved that there existed an employment relationship between the claimant and defendant herein, an assertion which is not disputed by defendant. Further to this, claimant tendered the employment contract Exhibit JNK 1B, which is a binding agreement between parties and the bedrock of any case where the issue of wrongful termination of employment calls for determination. See United PLC and Aqua. Seeing that this employment is governed by the employment contract, Exhibit JNK1, the nature of this employment will be adequately and rightfully described as master servant. And the master servant employment can only be said to be wrongfully terminated if done contrary to the conditions governing the particular contract of service, or in a manner not contemplated by the stipulations in the conditions of service. More so, in determining whether termination of an employment contract is wrongful or not, the court will consider whether A, dismissal was carried out in line with the procedure laid down in the employee handbook or any document governing the employment relationship. B, termination was carried out by a competent authority. C, employee was afforded fair hearing. C, Momo and CBN, amongst other cases cited. As can be seen from paragraphs 10 to 12 and 19 of claimant's witness statement on oath, his employment was terminated without reason and notice. In addition, it was terminated 5 months before the effluxion of the contract of employment. Now, paragraph 2 of the terms of contract, which is Exhibit JNK1B, provides thus. Titled Termination. Either party shall determine this contract by giving 1 month notice or payment for the same period in lieu of notice. This provision is express and simply prescribes that a month's notice be given by either parties or payment of salary in lieu of notice. In essence, compliance would be that the defendant gives the claimant 1 month's notice, and where it fails to give such notice, it is required to pay salary in lieu of notice contemporaneously, C or Forishe and NGC Limited, amongst other cases. Whereas by Exhibit JNK2, defendant abruptly terminated the employment of the claimant via the letter dated 3rd August 2018, effective same date, and from my perusal of Exhibit JNK3, which is statement of account of claimant from 31st May 2011 to 4th February 2019, it is clear that the defendant failed to pay to the claimant the prescribed salary in lieu of notice. This is in clear contradiction of the terms of contract governing this employment relationship. Therefore, the defendant is in breach of employment contract. Thus, the termination of employment of claimant is wrongful, and I so hold.
As the court pleases.
On the quantum of damage to which the claimant is entitled, the court is shifting from the draconian position of law that an employee whose employment has been wrongfully terminated is only entitled to salary in lieu of notice. Presently, where an employer brings an employment to an end in a manner contrary to the terms stipulated in the employment contract, the quantum of damages cannot be prescribed salary in lieu of notice. The quantum of damages awardable in such circumstance will be in accordance with the general law on contract on award of damages for breach of contract, while considering the consequential loss that may have arisen or would arise from the breach of the contract of employment. See Skybank PLC and Adegun Supra at 29 to 30, paragraphs G to C. I have quoted the pronouncement of the court. It's contained, it's a lengthy one. The claimant in paragraphs 10 to 12, 20, 24 of his witness statement on oath deposed to facts to show his consequential loss resulting from his wrongful termination. The depositions in these paragraphs are reproduced below. I have them reproduced in paragraphs 10, 11, 12, 20, and 24. They have been captured here in the judgment. I must emphasize that it is no longer fashionable for an employer to terminate employees' employment without reason. Per Ogunwumiju JSC, in a concurring judgment, Skybank versus Adegun Supra, held that, I quote, in Nigeria, the primary regulation governing employer-employee or master-servant relationship is the Labour Act of 2004. According to sections 11 and 20 of the Act, an employer is entitled to terminate for good reasons such as misconduct, incapacity, redundancy, or genuine organizational restructuring. Furthermore, the Act stipulates that employees must be provided with reasonable notice unless there are cases of gross misconduct that justify summary dismissal, unquote. See also Article 4 of Termination of Employment Convention 1982, number 158. In this instant case, the defendant abruptly terminated the claimant's employment for no reason. The letter of termination of employment reads thus, I quote, we regret to inform you that your services are no longer required in the company, effective Friday, 3rd August 2018. Please submit your handover notes and all corporate projects and resources limited and NASA's properties, including computing, vehicular and telecommunication resources in your possession to the program officer, PRO Kebbi. Kindly contact the administration department for the payment of your entitlement. We wish you the very best in your future endeavors, unquote. Generally, employers are at liberty to terminate for good, bad reason, or no reason at all. However, the courts are now shifting from this position of law and now embracing modern labor best practices, as encapsulated in Article 4 of Termination of Employment Convention 1982, number 158, which provides that the employment of a worker shall not be terminated unless there is a valid reason for such termination connected with the capacity or conduct of the worker or based on operational requirements of the undertaking, establishment, or service, unquote. Be that as it may, I find it difficult to deduce a reason why the wordings of the letter of termination may be the cause of claimant's inability to sustain another employment. That is to say, I'm of the firm opinion that the defendant's failure to give a reason for termination in this case, though no longer fashionable, cannot be held in this circumstance to be capable of forestalling the claimant from getting another employment. However, having held that an employer who terminates the employment of its employee without notice must do so with contemporaneous payment of his salary in lieu of notice, and the defendant herein having failed to do so, cannot be held liable to pay only the month's salary in lieu of notice, as that will amount to benefiting from his own wrong. See Skybank and Adegun Supra. The claimant has asserted that the abrupt termination of his employment caused him serious financial hardship and that the defendant failed to pay his entitlement. I find that the defendant is liable to damages as shall be prescribed in this latter part of this judgment. This shall be in form of general damages, which need not be pleaded or proved, as it is presumed by law as the loss which naturally flows from the act of the defendant and generally quantified by relying on what will be the opinion and judgment of a reasonable person in the circumstances of the case. See Ibrahim and Obaje, 2019, 3 NWLR at 1660 and 389, amongst other cases cited. Having held that determination is wrongful, would it suffice to grant claimant's claim for 1,503,000 being the salary he would have earned had the contract been allowed to run to an end as per Relief B? The ground upon which this relief is predicated is that the claimant was the contract staff. Said contract is to be renewable on a yearly basis. The defendant on its part asserted that the claimant's employment was never confirmed and admitted that claimant was the contract staff. Regarding the first leg of defendant's assertion that employment of claimant was not confirmed, the evidence before me shows that the claimant was employed on 1st June 2017, see Exhibit JNK1A, and the letter of employment described a period of appraisal of 6 months. This implies a probationary period, which was to last till 1st January 2018. By all implications, the claimant remained in the employ of defendant beyond the 1st of January 2018, wherein the claimant continued to render his service to the defendant, who in turn paid for his continued services. The question here is whether the claimant remaining in the employ of defendant beyond 1st January 2018 is tantamount to confirmation of his employment. Firstly, I must emphasize that a confirmation of employment is an employer's acknowledgement that an employee conducted himself and carried out his duties in a satisfactory manner. This oftentimes allows the employer to extend the employee's employment in accordance with the terms of the contract of employment. Now, paragraph 3 of the employment letter, which is Exhibit JNK1A, reads thus, I quote, as part of a consulting firm working for Nesal PLC, your terms of employment is attached to this letter. This contract is subject to appraisal after 6 months. Subject to satisfactory performance, your contract is renewable every year, dependent upon Nesal's renewal of contract on the project, unquote. It is tried that if after a probationary period, even where not specifically confirmed in writing, as in this case, an employee is encouraged to continue working by his employer and duly paid for his continued services, the employee is deemed to have been confirmed. COAU versus Onabanjo, 1991, 5 NWLR, Part 193 at 549. Thus, it is without any iota of doubt that are aligned with the claimant in holding that his employment was impliedly confirmed by the defendant on 1st January 2018, and I so hold.
As the court pleases.
On the second leg of defendant's assertion that claimant was a contract staff, thus his employment could be terminated at any time. It is indeed the law that a master servant employment may be terminated by either of the parties at any time, so far the terms of contract of employment is complied with. Moreover, the court will never foist a willing employee on an unwilling employer and vice versa. CUBN versus Chinyere, Adewumi versus Nigeria Eagle Flour Mills. Citations all provided. Nonetheless, it is not disputed that the claimant is a contract staff, and I firmly believe that said contract commenced upon his confirmation on the 1st January 2018. From Exhibit JNK1A, it is clear that this employment is to be renewed on a yearly basis. Thus, although not expressly stated in the letter of employment, the employment determines on 31st December 2018, unless renewed. This, to my mind, indicates that parties had a fixed-term employment. It is the law that where a contract of service is for a fixed term, the employee cannot be removed during the period of time, save where the employee is found wanting for misconduct or died. CSS Company Limited and Afropark Nigeria Limited, 2008, 18 Nigerian Weekly Law Report, Part 1118 at 77. The employer is required to pay to the employee the full salary that he would have earned for the unexpired period of his fixed contractual term. There is nothing before me suggesting that the claimant's employment was terminated for any misconduct. My stance is buttressed by the wordings of the letter of termination of employment, which was without reason, and the defendant was seen extending good wishes to the claimant hearing. Hence, I find that the defendant is liable to pay for the unexpired term of the contract, and I so hold.
As court pleases. As the court pleases.
I'm not oblivious that the defendant has alleged diversion of funds in its counterclaim against the claimant, which could be categorized as misconduct. However, this will be appropriately addressed when determining the counterclaim. The claimant is equally claiming for shortfalls in his pension contributions. So the claimant, defendant shortchanged him by paying the sum of 11,900 naira monthly instead of 54,112 naira 50 kobo, thereby rendering it liable for the sum of 42,100 naira monthly for 14 months. The law regulating pension contribution in Nigeria is the Pension Reform Act 2014, and therefore applicable in this regard. Section 4 and 120 of PRA are reproduced below. I quote, the contribution for any employee to which this act applies shall be made in the following rates relating to his monthly emoluments. A minimum of 10% by the employer, and B, minimum of 8% by the employee. Section 120, interpretation, defines monthly emoluments to mean total emoluments as may be defined in the employee's contract of employment, but shall not be less than a total sum of basic salary, housing allowance, and transport allowance, unquote. These provisions, in my view, are express, and it is the law that where the wordings of a statute are clear and unambiguous, the literal interpretation should be given effect. See Dangana and Usman, and equally Aromolara and Aguru, citations all provided. Accordingly, a combined reading of sections 4 and 120 of PRA 2014 implies that the defendant in this present case is statutorily obligated to make not less than 10% of the claimant's monthly emolument. The term monthly emolument has been adequately interpreted to be the total monthly emolument as provided in the terms of employment, or not less than a sum of basic salary, housing allowance, and transport allowance. The defendant in paragraph 6 of statement of defense equally outlined the claimant's gross total annual emoluments thus: the basic salary, 800,000, field work allowance, 1,200,000, transport reimbursable, 750,000, medical reimbursable, 460,000, communication reimbursable, 500,000, end of year bonus, 60,000, employer's pension contribution, 80,000. Total, 3,850,000. It further broke down claimant's net monthly emolument as follows: basic salary, 66,000, 66.66 per month, field work allowance, 100,000 per month, transport reimbursable, 62,500 per month, medical reimbursable, 38,333.33 per month, communication reimbursable, 41,066.66 per month, total 309,166.65. Less employee pension contribution, 5,333.33. Less payee tax, 3,208.33. I'm aware that the defendant in his pleadings averred that the statutory pension contribution is 18% of the basic salary, which was computed as basic plus housing plus transport. Further, that the claimant being a contract staff was not entitled to transport and housing allowance, and that it only paid reimbursable transport allowance to the claimant. See paragraphs 8 to 10 of statements of defense. These averments, to my mind, hold no weight. The law is clear that it is either an employer pays 10% of the total emolument, and where it is not willing to do so, employer is obligated to pay 10% of a sum of the basic salary, housing allowance, and transport allowance of its employee as monthly pension contribution. The defendant has stated that the claimant being a contract staff is not entitled to transport and housing allowance. To my mind, this leaves the defendant with only one option, which is to pay the claimant 10% of his total emolument and not 80,000 per annum pension contribution as indicated in the terms of employment, which I must say is not capable of vitiating a statutory provision such as the PRA 2014. By my calculation, 10% of claimant's total monthly emolument of 309,166.65 is 30,916.66. Evidence before me shows that the defendant was remitting 6,066.67 as is part of the monthly pension contribution instead of 30,916.66. See Exhibit JNK3, Statement of Account of Claimant Retirement Savings Account. Thus, there is a shortfall of 24,249.99. Since the claimant has pleaded that the defendant should change him in payment of his monthly contribution for a period of 14 months, and said period was not challenged by the defendant, it is deemed admitted. Hence, the defendant is liable to pay a shortfall of 339,499.86, and I so hold.
Scott, please. As the court pleases.
In addition, I am aware that the defendant also deducted below the amount that it ought to have from the salary of the claimant to remit as the employee's contribution to his retirement savings account. Thus, instead of deducting 8% of the claimant's total monthly emolument, which would amount to 24,733.33, the defendant was deducting 5,333.33. Thus, defendant paid an excess of 19,400.02. However, seeing that this sum was already paid as salary to the claimant, it would be unreasonable and excessive to direct that defendant repay said sum to the retirement savings account of the claimant, and I so hold.
As the court pleases. As the court pleases.
Which is whether defendant counterclaimant has proved his counterclaim to be entitled to relief sought. Defendant counterclaimant has a counterclaim which must also be determined, as it is a separate, independent, and distinct action in which the counterclaimant has the burden to prove his counterclaim. See Olonade and Showemimo, equally Dala Air Services versus Sudan Airways. The crux of defendant counterclaimant's counterclaim is that the defendant to counterclaim diverted the sum of 520,000 naira and that he failed to refund the money. Consequently, the counterclaimant subtracted the defendant to counterclaim's terminal benefit of 327,145.21 from the 520,000 naira alleged to have been diverted, leaving an outstanding sum of 192,854.79. It is for this outstanding balance that the defendant counterclaimant is now counterclaiming and for cost of suit. From the totality of evidence adduced by the defendant counterclaimant, I am of the firm view that it has failed to adduce any evidence whatsoever to the effect that the claimant and defendant to counterclaim diverted its funds. This has left the counterclaim bereft of any substance and burden of proof on discharge. It is tried that pleadings do not constitute evidence. Where pleadings are not supported by evidence, such pleadings are deemed to have been abandoned. See Bamidele and Bello, Unilorin and Adeshino, and equally Ali Company Limited and Ghani, citations all provided. In this instant case, the defendant counterclaimant failed to show or prove that the alleged sum was in the custody of the claimant and defendant to counterclaim. Neither did it adduce evidence to support its averment that the sum was diverted. All the defendant counterclaimant presented before the court relating to his counterclaims was a letter of demand dated 24 September 2018, directing the claimant and defendant to counterclaim to refund the said sum. This, to my mind, is skeletal and fundamentally insufficient to lead to grant of relief sought by the counterclaimant. Consequently, the counterclaim fails in its entirety, and I so hold.
As the court pleases.
On the whole, this suit is hereby determined as follows. Reliefs A, B, D, F succeeds. Relief C and E succeeds partially. Counterclaim fails in its entirety, and it is hereby declared and or ordered as follows. A, the termination of the claimant was wrongful and in breach of the contract of employment. B, defendant shall pay to the claimant the sum of 1,503,000 naira, being the amount of the money the claimant would have earned had the defendant allowed the claimant to work until the end of December 2018. C, defendant shall pay to the claimant's retirement savings account the sum of 339,499 naira 0.86 kobo as shortfall in claimant's monthly pension contribution. D, the defendant shall pay the sum of 36,933 naira as bonuses due to the claimant. E, the defendant shall pay to the claimant 500,000 naira only as general damages for wrongful termination of employment. F, defendant shall pay to the claimant the sum of 100,000 naira as cost of action. Judgment is hereby entered accordingly.
As the court pleases. As the court pleases. My Lord, on behalf of the claimant, we most humbly thank the court. And as is always my tradition, we want to thank the court for the patience from the commencement to conclusion of the case. And if at any point in time we offended or acted in any way that is unbecoming, we sincerely apologize. Once again, we thank my Lord.
All right, counsel, thank you.
We thank my Lord for this well and deserved judgment. Thank you, my Lord.
Thank you, Aminu.
Thank you, my Lord.
So I think that should be all for Sokoto. So I think, counsel, you are free to exit the platform so that we can continue with the Abuja matters.